Welcome back to the show. I'm John Knocklinger, the men's divorce coach and mentor. You can join our free men's divorce support group at mensdivorcenetwork.com. Today, my guest is Lauren Bercik. She is an attorney and the owner of Bercik Law in New Jersey, where she handles estate planning, estate litigation, estate administration, adult guardianships, and special needs issues. She's been doing this line of work since 2004, so she knows what she's doing. So everyone listen up. I've known Lauren for 20 years, and I can attest that, in my opinion, she's one of the best estate attorneys in the country. I also am happy to call her a friend. You can find out more about Lauren at berciklaw.com. That'll be in the show notes. It'll also probably be on your screen if you're watching this on YouTube. Thank you so much for being here today, Lauren.
Thanks so much for having me, John, and thanks for the vote of confidence in the intro. Greatly appreciated.
Oh, absolutely. Well, you've been doing this for 20 years, so you've seen it all. You've done it all. But let's kind of start sort of really basic, Lauren, for our listeners. Why do you need to go see an estate attorney if you're just some regular, average person out in the world?
Well, every person, regular, average, low, high, whoever you are, we can only guarantee one thing in life, and that's you're going to pass away at some point in time. And for most people, we really don't know when that's going to be. Everyone, most people think it's always another day. They have more time. And while that's something, it's very unpleasant and none of us want to think about it. And oftentimes that's why people don't do estate plans. But by making an estate plan while you're healthy and can express your wishes and think about these things, who is important to you and what would be important to know that they're taken care of if you are to pass away, is the reason to do it. Because oftentimes families are left in chaos.
So what about the person who says, but I don't have any money. I don't have any kids. Like, why would I need to do a will?
Well, because we don't know what we're going to have when we pass away. Sometimes the people that are single are the hardest to plan for because they have to think about very hard topics. And especially, people going through divorce where the natural course of planning would be with spouses, each to the other, and then to the children. If there are any, it goes away. But when you don't have an estate plan, there's a few things that happen. One, the government is going to tell you what they think is right for you or your family or whoever it is that you've left behind, because there are always heirs, no matter what, whether they're your parents, they're your siblings, your nieces and nephews. And in some cases, I have a few right now, distant cousins that we have to track down all over the globe that never even knew you existed. But now they're going to receive your money. More importantly for yourself, things that go into an estate plan are not only the will. And I say for you as the client, the will is the least important part of the plan because you're not here. And while it's a great gift to leave to your heirs or your loved ones, what is more important for you is the power of attorney and advanced healthcare directive and proxy. Because if anything were to happen to you, whether it was in an accident or some other event that you can no longer speak for yourself, whether you've been physically disabled and now you can't express your wishes, or mentally unconscious or incapacitated that you can't express your wishes, someone else will be making those decisions. And if you take the opportunity to express those wishes and what you want while you are still healthy and can speak, it makes all the difference to what type of care that you might get. If you become mentally incapacitated for some reason, it could be an accident, or if you're older, it could be dementia. And some people are developing dementia even in their 50s, that if you can't make your decisions, someone will make them for you. And either someone will have to go to court to become your guardian and make all of your decisions for you. And then in some instances, if there's no family or a close friend to step up and do that, here in New Jersey, there's something called the Office of the Public Guardian. If you're over 62 and you don't have anyone to take responsibility for you, you actually become, for all intents and purposes, a ward of the state. And the Office of the Public Guardian makes your decisions for you, a bureaucratic agency. And they take care of all of your finances and medical decisions, where you're going to live, what you're going to eat, where you're going to be, everything. Same thing with advanced healthcare directives. You have an opportunity to express your wishes. If you come to the end of your life and you're unconscious, you can express what medical care you want or don't want, which is just as important. And for your family members, I usually say this is the best gift you can give your family, because if they have to make that heart-wrenching decision during one of the most awful parts of not only your life, but their lives, to have to decide whether to artificially extend your life or let you pass naturally, it's a very difficult time. So if you've expressed those wishes, it's really take some of the guilt that's involved. And that's where I say it's a gift, because that terrible guilt and having to make end of life decision and care decisions for your loved one is one of the most difficult parts of someone's life. So that way, if you've expressed your wishes, it really helps to guide your family later on. So that's why for everyone, an estate plan is important, even if you have nothing more than your house and your car.
Yeah, I think that just the decision making when it comes to medical issues is enough of a reason to pinpoint who you want making the decisions. Because otherwise, I mean, Lauren, if you didn't have a medical power of attorney, who is it that's likely to be the one to make decisions about your life?
Yeah. Well, this would be in a long-term scenario. This wouldn't be as a matter of you're in a car accident. Sometimes I do explain to people, even if you had your healthcare proxy in your hands and you were in a car accident, they will revive you. This is only in very certain circumstances, and the circumstances would then be, for the end of life decisions, is under three scenarios. One, if you have a terminal illness, which means there's no medical care, there's no medical cure for what you're doing. There's things that may extend your life, but they're not curative. So you are terminally ill, and oftentimes you're in the active process of dying. You're not going to get well. And then the second part is if you're permanently unconscious, and that would be, based upon the opinion of at least two medical professionals. Now, the third is if you have a dreaded and incurable illness, which is really open to a large gamut of things, which could be anything from a dementia or some type of cognitive disability that's degenerative, up to, you have a Lou Gehrig's disease or a severe form of multiple sclerosis. And what that is a little bit different for everybody. But oftentimes it involves a tremendous amount of pain, suffering, and disability. The other part of the healthcare directive is just the healthcare power of attorney, where if you are unconscious due to, it would be pretty much a catastrophic accident where you'd be lingering in the hospital for an extended period of time. You would need someone to make healthcare decisions for you until you recuperated.
And these directives that are drafted, are the doctors compelled to follow them to a T, or is there wiggle room for the decision maker that you've appointed?
Well, there's always wiggle room on the healthcare proxy, because as many situations as there could be in the universe, that's what could present itself. So with a healthcare proxy is healthcare power of attorney. Just like a financial power of attorney, you have the ability to consent to treatment, withdraw from treatment, not, decline treatment where you want to be treated. So all of the decisions that you would normally make when you're encountering healthcare professionals in that type of setting, your power of attorney or healthcare proxy would be able to do. The second part of that is the advanced directive. They usually are in one document. So it'll say healthcare proxy advanced directive. So the healthcare proxy doesn't necessarily mean you're in one of those dreaded scenarios that I just mentioned, but it could be that you've been incapacitated due to an accident and you can't speak for yourself. Say it could be in any number of, I used to be a nurse, so I can come up with a million scenarios about how that can happen. But the healthcare proxy is just the power of attorney, and the doctors will follow it. The same thing with the advanced directive. They will honor it.
All right. Now, of course, we live in the day and age of the internet, and there's all these forms out there on the internet you can buy. So, what is, I mean, some of this is self explanatory, but I think I always like to remind people how important it is to go speak to an attorney, even though I know it costs more than going on LegalZoom or any of these other places. But what are some of the benefits that you really can get by coming to a meeting with you to prepare all these documents, Lauren, versus going on there? I mean, we just heard one. You're an ex-nurse, so you can talk a little bit more about all these scenarios. But why don't you give our listeners an idea about why should you spend a little extra money to get an attorney to prepare these forms?
I'm so glad you asked that question because when LegalZoom was, I presume it's still popular, I would say, I love LegalZoom. And people look at me like, why would you say that? Because they're so often done incorrectly. They're executed incorrectly, they're filled out incorrectly, that instead of coming to me and perhaps spending $1,500 on an estate plan, and I know that's quite a bit of money, they spend $8,000 to correct it when your beneficiaries go to probate the will and then they find out that it's not been done correctly. Now, not only have they lost you, they can't really administer your estate until they now spend at least $5,000 to $10,000 to go to court to correct whatever you potentially did wrong. And sometimes it's more than that, because if it's ambiguous, it creates litigation among your family members. So, as far as the will, there's certain formalities that are required for the court after you pass to probate the will by the circuits court to authenticate it, and the documents can be confusing. You need 2 witnesses and a notary, and there's something called a self-proving affidavit that also needs to be attached to it. If you don't fill out the self-proving affidavit, your loved ones left behind now need to go search out for your witnesses to sign witness forms, oftentimes years later if they can even be found. So if it's not executed correctly, you still might be able to establish it with probate, but it would be a lengthy and more expensive court proceeding, delaying the probate of the estate. Also, the terms of the will, people don't always fill the forms out correctly, and they'll accidentally delete something that should be there. Maybe they thought it didn't have to be. They don't appoint an executor, or they don't appoint a alternate executor, alternate beneficiaries. There's so many iterations of what people do incorrectly, and I've even seen ones from LegalZoom I've dealt with where they fill the form out, but then they write on it in their own handwriting. So that's a whole nother court application, whether whatever you expressed in your handwritten notes are part of the will or not part of the will. So if you want to really make sure that it's done correctly, the best thing you can do is come to an attorney. I mean, people have written scraps of paper in the hospital. I intend this to be my will and put it in their wallet. And then I probate the little scrap of paper that says, I wanted Sally to get my house. And of course, that's another very long court application. So if you go, it brings up issues that otherwise may not come to light. Sometimes people have children from other relationships and they're not considered, and what the ramifications are of that. Or there's also times where people get married and then they go their separate ways, but they never legally divorce. And I think you're familiar with that scenario with some of your cases, John. But at the time that you pass, that can cause a problem, because if that person's your spouse, they may be able to claim your estate even if you haven't spoken to them in 10 years, because they are your legal spouse. If you don't have a will, they can claim your estate.
Yeah, I think what I want to get into a little bit about what happens if you're going through a divorce and you're not, you don't take the attention that you just talked about to your estate planning, some of the ramifications. But going back to just doing a will, there's a lot of people. We live in a country where people are moving constantly, right? All over the place. Sometimes people have multiple residences. Sometimes they're marrying, they're getting married, or maybe their spouse lives in one state and they live in a different state. There's all kinds of scenarios out there. So I guess one of the questions I have is, where do you have to execute a will for it to be binding? And then whenever you die, Do you use the laws of the state where you die, or is it the laws of the state where you entered into the will?
That's a great question. You make a will in the state with which you are domiciled. You can have, and this is a legal art. You can have many residences. You could have five. If you win the $2 billion now, you can have 20 residences or 50 residences in every state. But you can only have one legal domicile, and that's for the most easy way to put it, is your home base. And that's the state where you file your taxes. That's where you would be registered to vote. And that's really, and usually your main residence, or you supposedly spend the most time there. So you would do a will in what state would be your domicile. And in this scenario, between New York or New Jersey and Florida, this happens quite often. People are snowbirds and go back and forth. But whatever you claim to be your domicile for tax purposes is the state where you make the will. If you validly execute the will in the state where you've had it done, then it would be recognized in all 50 states as a general rule, as long as it's validly executed in the state where it was made. So if everything was validly done in the state of Florida, state of New Jersey, wherever it should be, then it should be recognized in all 50 states.
So is there any benefit? I mean, obviously you practice in New Jersey. You may have some familiarity with New York or Florida for the reasons you just said, but is there any benefit to your heirs to having it done in one state versus another? I mean, we call it forum shopping in the legal world, but is there any benefit, or is it really just how the documents are executed, but how they're going to be enforced is very similar?
The laws of probate are different in every state. So your will is probated in the state in which you're domiciled. So you can't forum shop. You would have to legally change your domicile. There's no the laws of whatever state you're legally a resident of. So say you have the will done here in New Jersey, you're a New Jersey resident, it's executed here. You now retired to North Carolina and never do a new will. You pass away as a resident of North Carolina, the New Jersey will is operative, and they would recognize that. But what would apply is whatever the laws of the state are where you passed away. We always tell people if they're going to relocate to a new state to make that their new home, their domicile, they should have the will reviewed because the laws are different in every state. And just by way of example, you'll hear in Florida, sometimes New York, California, you have to do a trust. You have to do a trust. Avoid probate at all costs. It's very expensive. Don't go to probate. Get the trust, the living trust, the revocable trust, the irrevocable trust, whatever it may be. Because in those states, or some states, probate is supervised by the court. It's lengthy, it's expensive, and you do want to avoid it to make it more simple for your beneficiaries. In New Jersey, that's not the case. We don't have court-supervised probate unless someone asks the court to become involved. So where, I've seen things cost $10,000 or $20,000 to probate in Florida, it's $200 in New Jersey, $100 to $200 to open a probate here, because it's not court supervised unless someone complains. Usually a beneficiary goes to the court and says, I want this executor supervised.
Okay. Well, that makes a lot of sense. So when you're dealing with things that are being probated, I just know, because you've given me such education over the years, there are certain things in your life, certain financial assets that don't go through the probate system. So in giving advice to people that you're working with, are there certain things you tell them, why don't you set this account up this way so that you don't even have to deal with the probate system and the money can get to your heirs quicker?
That's right. And what happens now, which is different from many years ago, is that oftentimes very little flows under the will. So when my clients come to me, I want to know what their beneficiary designations are on all of their accounts. A very common misconception, and this is where some plans have gone not the way they were intended, is people have an erroneous belief that the will trumps the beneficiary designation, and it does not. So one of the things that we have to evaluate, and this is another point to use an attorney, so one of the things that I need to evaluate is how the funds are going to flow, because they flow probate and non-probate. Non-probate is anything with a beneficiary designation. Probate assets are the ones controlled by the will. I can have someone with $7 million of assets, but the only thing that's going to go under the will is their house, if they're the second of a married couple to die or they own the house individually, their house, their car, and probably their checking and savings accounts, or what I call the operating accounts. Otherwise, everything typically is offered by beneficiary designation, whether they're retirement funds, which have a lot of their own idiosyncrasies. Since they've passed something called the Secure Act, your heirs have to take that out, except for your spouse, for the most part, over a 10-year period. Your brokerage accounts can have beneficiary designations. And the other important part of that is, who are the alternate beneficiaries on everything? I've seen unfortunate scenarios where, a single individual names his parents, but they both predeceased. He then dies in a tragic accident, and now everything is going to be paid to his estate, which can cause tax consequences that can diminish the fund by about half. So if there's 800,000 in the account, there might be 400 for your heirs.
So in terms of those beneficiary designations, if you're going through a divorce, and let's say you've named your spouse on all these beneficiary designations, and you forget to take your spouse's name off, which I don't know how anyone could forget. When I got divorced, it was the first thing I did. It was like that day, everything was being changed. But what happens in that situation? Are the laws such that we just disregard that beneficiary? Yes. Or what happens?
In most states, and not in all, but in most states, or some, I qualify that, not most, I don't have a survey of all 50, but in quite a number of states, there's a statute, there's a law that says that if you're divorced, and I just had one of these cases, there were 3 life insurance policies and 2 other accounts with the name of an ex-wife. They'd been divorced since 1994, but her name still was on everything. But it's called the lapse statute or revocation statute. What it says here in New Jersey and many other states is that if you're divorced and you haven't taken your spouse's or former spouse's name off of the beneficiary designation, it's as if that person predeceased you. So that's the saying, "You're dead to me." So it's as if the person had died before you, which then passes it to whoever the contingent beneficiaries are, if there are contingent beneficiaries.
And if not, then to your estate.
Then it goes to your estate. And for retirement accounts and for life insurance accounts, it could have significant tax consequences to be paid into the probate estate. Now, part of you says, well, just let it go under the will. But for instance, something like life insurance, here in New Jersey, we have something called, for lack of any other way to raise money from the citizens of our great state, an inheritance tax. And that's a tax that the state of New Jersey exacts upon individuals based upon how they're related to the decedent. So if you're a nephew, you pay tax. If you're a sister, you pay tax. If you're a spouse or a child, grandchild, there's no tax. So it's merely a tax scheme to raise money based upon your relationship and how close of a relationship by blood you are to that person. So what happens is life insurance does not exact any inheritance tax, no matter who inherits it. But if it goes into the estate and then out, something, if you had $100,000 in insurance, you were going to leave to your friend Susie, she would receive it tax-free if she was the beneficiary. If it went through your estate, she would receive $85,000 of the 100 because of the 15% inheritance tax. So you've taken a non-taxable asset and you've now just put a 15% tax on it. With retirement funds, even if your children were going to inherit it, under the Secure Act, they have to withdraw it most 90% of the time. There's some exceptions. Most people would need to withdraw that, or children would need to withdraw that over a 10-year period. But then they can work with their accountants based on whatever their tax scheme is to help minimize that tax. On the other hand, if it's paid to your estate, you have $1 million of retirement funds, that would all be taxed in the year of your death, because it would all be taken out and put into the estate account. There's various ways to save it from that, but this is where having an experienced estate attorney, even after someone's passed, to be able to evaluate whether there are some techniques to avoid paying tax all in 1 year.
Yeah, sure. And you're talking about who you're leaving things to. When people are going through a divorce, it's very, very common for there to be a life insurance obligation, either to the ex-spouse because of alimony or spousal support, or for the children. And, divorce attorneys, much like estate attorneys and everyone else under the sun, are not all made the same. And so agreements are not all drafted very clearly. So, a lot of times people will see this life insurance obligation, and the other person, it's like out of sight, out of mind. I'm done with the divorce. I don't ever want to see this person again. So you go on through the years and this person doesn't have a life insurance policy and they die. So I think it's important for our listeners. Can you explain what happens in that kind of situation?
Oh, I've spent many years on this issue. Well, on the planning side, if you go to an experienced estate planner, and I realize that someone's reported as being divorced, one of the most important questions to avoid post-mortem litigation between the family members is, how do you have your support out? Do you have a support obligation? I want to see your marital settlement agreement and make sure that everything is taken care of. Because, like, as you've accurately stated, hell hath no fury like a breached marital settlement agreement after you're gone, especially in the scenarios where your second husband or second wife is receiving that policy instead of your former spouse or your children from your prior relationship. So what that does is, if you don't have your obligations really spelled out and secured, your next spouse will have the fury of your former spouse or your children's other parents coming after them. If you don't have your child support life insurance in place, it's an obligation of your estate. So the people that you do have named on your life insurance can be obligated to pay that over to your child or your children or your former spouse, or your estate has to pay it. So if there's no life insurance at all, then what would happen is you had a $250,000 support obligation at the time that you died. The first $250,000 before any of the beneficiaries of under your will would get it, would go to take care of that obligation. Or on the other hand, you'll have a fight over a life insurance policy about how that's going to be broken up.
Yeah, and
We're just inviting litigation.
You are, and a lot of times the cost of the life insurance policy is minuscule compared to how much you might be depriving your other beneficiaries of their share of your estate. So, you think you might be getting one over on your ex-spouse, where
you're not.
You're not, and you might just be hurting your beneficiaries a lot more. Now, you were talking about how life insurance doesn't pass through probate. So if the ex-spouse gets $1 million life insurance policy, and let's say the estate has nothing in it, can they come after that $1 million policy that the new spouse got to satisfy obligation for the ex-spouse?
Yes. If there's life insurance policy, and now we'll get into the weeds a little bit. Say you leave your new beloved $500,000 policy, but you had a $200,000 obligation under your marital settlement agreement, whether it's for alimony or child support. That there's nothing else to be had. The former obligation, because that's a breach of a contract, but they have an interest, and the court can impose something called a constructive trust, which would allow the life insurance company to give 200, to break it up 200,000 to satisfy the obligation, the contractual obligation, and then the remainder to your current spouse. But you didn't want your current spouse to get half of your policy or 60% of your policy. You wanted them to get the whole policy. And it becomes a little complicated because there are times where people have their insurance lapse, and if they're not working anymore, they may not be insurable. So that's where, there's a scenario where people, for whatever reason, they either, forget about it, think they don't have to have it anymore, want to get even with their spouse or whomever, and not carry the insurance. But then there's other scenarios where people are no longer working, and so when they stop their employment, if it's secured by a work policy, they're no longer, if it's not, usually you can continue to pay on it, but they forget about it, they don't think about it, and then next thing you know is they have some type of illness and they don't qualify for life insurance. Or that the cost of the premium is so high that it's not even affordable. So as long as you have a life insurance support obligation, secured with life insurance, you really have to have think about what change. If you're making any changes in employment, or the term is ending before your obligation is up, you really have to take a look and make sure that's secured, because if something happened to you, it really is that provides very contentious litigation, because there's a lot of emotional baggage that goes with some of these issues.
Sure. So it sounds to me that if that's your situation and you lose life insurance for whatever reason and it's too expensive to get a new policy, really you can either call Lauren and maybe adjust something in your estate plan to satisfy the obligation, just so it's clear, or you need to call your former divorce attorney and find out, is there a different way? Can we move maybe the obligation from life insurance to maybe a retirement plan as a beneficiary or something? Mm-hmm. Maybe we can reduce it. Maybe it's been 10 years I've been paying support, and my first attorney wasn't as savvy enough to reduce my obligation as I was over the years. Because that happens. I remember mm-hmm. a case that I heard about from you, Lauren, where there was a child in college that had a deceased parent, and there was still mm-hmm. a support obligation, but there was no language saying that there was any diminishment of that future obligation. So clearly, yeah. If you read a term of a contract and it says they're entitled to whatever it is, $500,000, whether you have 6 months left or 10 years left.
That's right.
All you're doing is fighting. And do you want your whole family to be fighting for what? These can go on for years, can't they?
Yeah, the scenario that you talked about went on for 6 years. And it was 6 years. There was no step down clause. Now, I think things have evolved in family. I'm not a family law practitioner, but what I see as with a lot of these ones that come through my office to be looked at for estate planning is that there are more step down clauses. And the ones that don't have them are ones that really have just a minimum, a smaller, more modest amount to secure the obligation. But otherwise, it's the argument became, well, he has 2 years of school, and that was put in place in 1994 when he was 7 years old. Now it's what is a windfall? Does this young person receive a windfall? And I had a different scenario where we were fighting over the policy. How much of that policy should that child get? The MSA says he should get $100,000, but he was 6 months away from graduation. So the decedent's current wife said, well, he's receiving a windfall because I'm a widow and I'm not working and I'm going to be impoverished. And he's going to receive a windfall because he's graduating in 6 months. I have no problem providing for something, but maybe not X. So it really does. It leaves a lot of problems for the person that's inheriting that policy. And sometimes it's a new spouse, sometimes it's just a domestic partner you're not married to, and that makes it even more complicated because if you have assets, they're just fighting. It just complicates everything.
So what's important then, I mean, you've been talking about the importance of estate planning so that you leave your whole family a better situation when you've passed on. So what we're talking about is even if you do your estate planning, if you don't do it all correctly, if you're not fully educated about all the things that are going on, if you're not dealing with an experienced attorney that can sort of guide you, you can inadvertently be creating issues for your family where your intention was to create no issues for your family.
Right.
It's really important. So, okay, one last issue before we have to go is you start going through a divorce, you filed for divorce. At what point do you recommend people start changing all of their stuff, their beneficiaries, their will, all these things? Because once you file for divorce, we know it could go on for a very long time. So when do you recommend people start making those changes?
I would make those changes if we think it's going to be a protracted, contested process. If it's an uncontested divorce and it's going to go through, now obviously anything could happen at any time. But, if you are secure that, unless some tragedy befalls you and you have many years ahead of you, you're not divorcing. Most people that are terminally ill are not divorcing. Unless it's for some type of long-term care planning. But, I would, if it's going to be protracted, sooner rather than later. And though that will is going to be in 2 steps, because if we're going to say there'll be 3 years of divorce litigation, as long as you're married, there's a minimal amount that you have to leave your spouse as a matter of law here in New Jersey. Other states have other laws and other governing structures, but what do you call those? What do you call those states where?
Community property states. Is that?
Thank you very much. Community property states. We don't have any around here, but yes, I know I've dealt with them. They will have other theories to getting your will done, but here in New Jersey, it's a protracted process. You can do a new will, leaving things to your new heirs or your new beneficiaries, but also cite in there that you're leaving your soon-to-be former spouse what they call the elective share, or the minimal amount that person's required. If you just leave everything to someone else, that soon-to-be former spouse can come back and try to make a claim. And it gets messy where you've moved on to a new relationship. You've left someone to your new intended spouse, or someone, whoever your new relationship is, but you haven't finished up the divorce. The spouse that you're leaving, who's probably not in a very good mood about it, is going to have a claim against your current love interest, or whomever your beneficiaries are. Now, if you're leaving everything to your children, is your wife going to try and take things from the kids? I don't know. I don't know. But there's a will that you can do that can be for that interim period. And then after that, even if you don't do another will, remember, once you're divorced, is as if your spouse predeceased you. However, once all the dust settles, it's good to take a look at the marital settlement agreement, make sure all your obligations are properly accounted for. And that's the difference between going to an experienced estate planner that's going to look at it as an individual basis, as opposed to something more discounted.
That's a nice way of saying it.
Yes. And I'm not going to say anything about other attorneys that do wills, because I'm sure there's plenty of them out there that were $300 and they did what they needed to do.
Sure. And I mean, we didn't even get in. I mean, obviously, we've scratched the surface, but there's all kinds of things you need to think about when you've got minor children in terms of you don't want to give a minor child $1 million. So there's other things you've got to think about. But that's why you go to someone experienced like Lauren so she can
Mhm.
do it the right way, tell you everything you need to know. And then as your life evolves and you get into new relationships, have new children, whatever, you come back to Lauren. You say, what changes do I need to make so that you can make it
Right.
as good as possible for your family whenever you pass on,
Mhm.
unless you just want to be looking down at them, laughing at them, you know, going after each other's throats, which I don't think many
Now,
people want to be doing.
in the end, oftentimes the only winner that comes out of all of that is me. You
Yeah.
know, and that's really not what you want for your kids, your family. I think especially for children, I've seen where, the parents are divorced and the children are now, 19, 18, 19, and they become the administrators of an estate. They have no wherewithal to be administering because there was no will, but they are the heirs. And they've just lost their parent. The person that's really guiding them is now your ex-spouse. It's really, when I say that it's the best gift you can give your family, it really is. And it's the type of peace of mind and orderly administration of things during a very difficult time.
And that sounds like a great way to market estate services is the best gift you can give your family. So I think
Mhm.
that's a good place for us to end. Lauren, if someone would like to come meet with you and learn about how they can best protect their family, how would they reach out to you?
You can reach out to me at the firm by calling 732-483-6300. We have communication through the website bersiclaw.com, or those are really the best ways to do it. Just give a call or fill out the form, and we'll have someone do an intake and call you back. Try to make the process as seamless and less painful as possible. But, I think especially for the people that have been avoiding it because they do have difficult things that it's hard for them to address, we understand and we help you work through them. And even though you haven't done it in the past, it might be messy. We can get it into help you get into some kind of order. Every day is an opportunity to try again.
Absolutely. And so even if you're young and think you're an
Mhm.
invincible person, go have a call with Lauren.
Yeah.
See what maybe she can do to help you and your loved ones in the event you have you know, an accident or something that happens. But thank you so much for being here
You're
today,
welcome.
Lauren. I learned a lot today, and I've talked to you about this all the time. So I know that our listeners learned a lot as well.
Thanks for giving me an opportunity.
You're welcome. Take care.
You too. Bye bye.